All right, we're recording now. This is John Milburn for 12062 Alternative Dispute Resolution, and welcome to week number 1. We've got a number of people online. We're getting a little bit of feedback. I want to ask if you're speaking into the microphone, and appreciate that. Nasir, I'll have to mute your microphone. I'll do that for you there. Jackie's joined us, Emma's joined us, Ellen's joined us. We've got a number of people here now. I'm just muting some microphones. If you wish to ask a question or make a comment, please unmute your microphone and do so. There's no such thing as waiting till the end of our session to ask a question. Immediately something comes to your mind, please feel free to participate and share. Also, we've got the chat facility. Those of you that are new to the Zoom regime, it's now becoming the norm throughout the law school. I've been using it since about 2012. The other thing that you'll probably notice with me is that I use UCrew, which is something perhaps new to those that haven't worked with me in the past. And if you haven't found your way to UCrew, please do so immediately, because that's where we do most of our chat facilities. It's not one way in UCrew. My intention is that it's interactive, both between us, as in me and you collectively, but also between students. And I'm always amazed and very happy with the quality of the work that people provide to assist each other. And UCrew is a really good forum for that. And you can assist each other in a couple of ways. The first is, on UCrew, you can upload information, links, comments that you find useful for others to consider. The second is that you can respond to what people are saying on UCrew. That might be me, or it might be your fellow students. And usually people are really helpful in terms of providing information, advice, and perhaps links for fellow students. It's also a really good way of exchanging information, and we have a great way of doing that right now, because for the first assessment piece, we need you to join into groups of 3 people. Don't worry, it's not going to be strictly adhered to. Sometimes our groups are groups of 2 people and an outside person, or there might be a group of 4 occasionally, but ideally, the way we've structured assessment number 1, you'd be in groups of 3. So as soon as you've found your 2 colleagues that you're going to work with for the first assessment, let me know either through UCrew post or send an email to me. And once we've got a note of that, I'll upload onto Moodle, the front page, the landing page, the group of 3 that are working together. So let's talk about that first assessment while we're here. Now, it is one where I'm going to ask you to work with colleagues, but you are being individually assessed. And you're being assessed on the work that you do as a mediator or a conciliator. The session that you'll record for me is one that can be conducted online, or it can be conducted face-to-face in the one facility, or a combination of both. You might have 2 people in the one area and 1 person online. So there's a number of ways you can complete that task. But bear in mind that I'm only assessing the work that you do as the mediator, as the conciliator, as the ADR practitioner. So why are we in groups of 3? Well, the way it works is this. You will determine whether you're going to be a mediator or a conciliator. You're then going to come up with a dispute scenario, something that's of interest to you. That can be consumer law, contract law, family law, it can be administrative law, it can be a neighbourhood dispute, it can be a workplace issue, it can be whatever you want it to be. You come up with a dispute scenario. You can borrow one if you like. If you're really struggling, just flip open any law report, go to a case, and just adapt the circumstances of that dispute and make it your own dispute. So you come up with a dispute scenario. Here's where personal preference comes into play. If you like, you can heavily script the dispute and hand that script to your colleagues and say, would you please play the part of Smith and would you please play the part of Jones? Here's the dispute, it's a workplace dispute, and here's what I want you to say. So that's one way of doing it. I discourage that. I'll mention why. Firstly, it's not much fun for the participants having to read off a script. And secondly, it really doesn't give you a good opportunity to showcase your ADR skills if people are working off a script. What I'd suggest you do is provide broad parameters for the people that are working with you and ask them to have a dispute in their own words as they see fit based around this scenario. Now, the scenario could be very brief. It might be, a dispute in relation to issues involving consumer dispute. And it might be that one party represents a company, the other represents a consumer, and it may be that you say, look, you can have a dispute about a washing machine, whatever it might be, and then it's amazing how quickly the participants actually get into this process of playing the part. And the less you know about what they're going to say, the better your ADR skills will show through. And we'll go through this over the next few weeks. What you can do, if you like, is I'll upload the take-home papers, if I haven't already done so, for last year and the year before. And you'll get an idea of what a dispute scenario looks like from that. So it can be very complicated or it can be very simple. I would suggest that you keep it pretty simple because you don't have a lot of time. And I do expect you to go through the process, including the opening statement, setting the agendas, identifying the real issues, and then possibly going through into private sessions. And we'll talk about that over the next few weeks. Okay, so in a nutshell, the first scenario, you find two colleagues that you're going to work with. You come up with a scenario, you pitch the dispute to your colleagues and say, look, this is what I want to do. Your colleagues may say, no, let's do something else, come up with some ideas, that's fine. They play the part of the people in dispute, and your job is to be the ADR practitioner. Once you've completed your task and you've recorded your session, then you just repeat the process twice. And that can be done on the same day, or it can be done over a series of days, whatever suits you best. So are there any preliminary questions about what I want to see in that first assessment piece? You can unmute your microphone or you can use the chat facility, whatever you prefer. Any questions at this stage about that first assessment?
John, I don't know whether it sounds a bit silly to ask or say it, but how are the other two in your group going to know? I get that we're going to give like a sort of a bare bones scenario, if you like, but then how are they going to know what to argue about? Just in terms of so that we can sort of employ what we've learned and what we know how in terms of dispute resolution. Yeah.
Well, again, it's amazing how people quickly respond to this task. And if you said to them, look, this is a dispute about company directors. It's a building company. We've got Dad, who's the sort of patriarch who wants to rule the roost, but Dad's really not keeping up with technology. He's not keeping up with the latest. And the other director is a daughter who is a registered builder, who is academically very qualified and wants to take the company in a different direction, but Dad just wants to do things old school. And there's a real dispute here about the scenario. I bet if you just said that to two people in the class and just said, look, can you just think about this a bit? By the time you start, people will get into it and they'll throw things in and they'll say, well, on that job that we had for, for brambles or whatever it might be, we really did lose out because we were doing things old school. We could have done it new ways, and people just respond. But having said that, if you want, you can work with your participants. You can say, look, here's the basic dispute, and then just sort of flesh it out a bit, and they might help with some ideas. If it's a dispute about parenting, they might say, oh, let's assume that there's disputes about schooling, and one wants to go to a private school, one wants to go to a public school, things of that nature. And just sort of, once you've got an idea of the nature of the dispute, then just try and fill it in and maybe work with the participants. That's a very long answer to your simple question, Tamara, but I hope that provides some assistance. Does that help?
Yeah, so it doesn't necessarily have to be something legal, as in, sort of throwing in cases and statutes and stuff like that. It can simply be, my neighbour keeps walking across my lawn, I've told them to stop and they won't stop, sort of thing. I know that's very basic, but it can literally be about anything you want. If we come up with an idea, are we more than welcome to email it to you to sort of say, look, what do you think of this? This is the scenario that I've kind of thought up. Yeah.
Absolutely. You can email it to me. Probably better if you ask, or if you mention it in your crew, just so that everybody can see what you're thinking, and just say, here's an idea that I've come up with. But you can email it to me. I'll probably say that's fine. And just to advance on what you've just said, the neighbourhood dispute, it might be, because of a trespass issue. And sure enough, the one that's being accused will fire back and say, well, I have to trespass because I have to collect my newspaper because you keep writing down the wrong address, to people, and my papers are being delivered at your place. Whatever, people will get into it straight away. So, but yeah, whatever the scenario you want, the first exercise is really practical. There's not cases. You need to understand the principles and the theory behind it, but it's really a practical exercise.
Okay, thank you.
Any other questions? Comments? Okay.
Sorry, John, I have one quick question.
Yes.
If I may. On the assignment document that was on Moodle, at the top of the second page, there's some information there which says that we don't have to complete the assessment video together during the one sitting, so we can do it in broken sittings. How would that work logistically? If would one person start and say a few things and then someone else would do it? Obviously, someone has to be together.
Yes. Look, I think what I intended to say in that, and what I expect, is that if you're the mediator or the conciliator, then your session would be filmed continuously, in the sense that you'd start the process and you'd run through and then hit the end recording button, and that would be what you send up. Now, if you're not happy with it and the others are happy to go again, then you can have another go. So there is that option, but generally people do the one and that's it. What I meant was that you've completed your task, then you might say, all right, well that's great. How about tomorrow we'll do somebody else's, and that can be a completely different session. So you don't have to do everybody in the one hit, but do record separately and upload separately. So you'll need to provide me with a link that I can access to view the work that you do. So I hope that answers it. Thanks, Jamie.
Yeah, thank you.
Any other questions, comments? Nothing on the chat facility? All right. Look, enjoy it. It's one of those rare things in this degree where you get to have some variety and have a bit of fun. Ellen, did you have a question?
Hi, yes, I do. I was just wondering, with the going backwards and forwards, so say my interpretation of mediation is you have your mediator, then you have your two separate parties in each, like in a different room, for example. So do we do our assignment where we approach one party and then we switch to the second party, or do we only just consult with one party? Does that make sense? Yeah.
Look, it does. The way in which you've described the mediation process that you're familiar with is what I would describe as a shuttle mediation process. Some mediators, some ADR practitioners almost invariably start in shuttle mode and work between the parties who are kept separate. My personal view is that that's not the ideal form of mediation session. It's certainly not the one that I use. What I use is much more of an open mediation style, where unless there's very good reason to do so, I'll start the parties in the same room at the same time. I'll hear from the parties separately by way of a short opening statement. I'll then work with the parties together to identify the issues and set the agenda, and then go into an open forum where you're participating with both parties and try to work to have the parties start to talk to each other. All of that comes after a short opening statement by me as the mediator or conciliator. So again, long answer to your question, Ellen, but my preference is you don't go into that shuttle mode. You work with the parties, as it were, together in the same room, trying to work through the process. I hope that answers the question.
Yes, it does. Thank you.
Right. Thanks, Ellen. Any other questions, comments? Don't be scared of this exercise. It's meant to be fun, and the sooner you join with find your group of three, and the sooner you agree on the technology you're going to use, and you identify the areas of dispute that you want to use as the focus, then then you can start thinking about it. And the longer you've got to think about it and sort of it grows on you and you talk to your colleagues, then I think the more natural, the better job you can do. Okay. Now, the second assessment is the take-home paper, and I'll give you, have I uploaded, can anyone tell me, have I uploaded the one from last year and the one from the year before that I wrote? No, I'll do that.
I don't think so, John.
Okay. All right. Well, I'll do that just to give you an idea of what you might expect. I'm away from Chambers for until Sunday, Monday, so I'll do that later. But it'll be somewhat similar this year. In the past, I've given very long periods of time for the take-home paper, and I've encouraged, actually almost demanded, that you speak to ADR practitioners in real life and try to work within the dispute in that regard. I'll probably change it. It'll be more theoretically based this year, so less actual contact with ADR practitioners, but I will still encourage you to access online and other resources by practitioners that you can incorporate to some degree in the work that you do. And there'll be a combination of practical skills and legal issues that need to be resolved in that take-home paper. So that's just a brief introduction to that part of the assessment. There'll be more as we go. When it comes to assessment, I do expect the work to be done on time. So the reason I'm speaking about this now is to give you the maximum time to ensure that we're ready to go by the due dates. They're a long way out, but don't delay. My thoughts are, let's get into it in week 1, because if you apply for an extension, odds are you won't get it, and you can't apply for an extension per se for the take-home paper. So be ready to go when we need you to be ready, and that means taking lots of preparation time. The first assessment is one that you'll upload through Moodle. You'll provide a link to your video in a Word document, and then upload the Word document. I hope that makes sense. I should say that it's pretty obvious. I do encourage people to collaborate, not collude, but collaborate. I'm very keen for lots of involvement between students in this subject. We're getting on in the course. We're getting on to the point where you'll be practicing. So I do want you to build these friendships, these relationships, because they're going to be valuable for you when you practice. And I should say that with this course, as in all the courses that I take, my focus is for those that wish to practice in law, or at least have a good understanding of the way in which people that do practice in law go about their task. I understand that many of you won't practice as lawyers, but it is a law degree, and the way I teach it is as if you're going to be practicing in law. So keep that in mind as we proceed. All right, now the textbook. Hopefully you've all received your textbook now. You've started to read it. Spencer's text. It's good. If you can't get the second edition, the first edition is good as well. And there is an online version that will serve you well if you like and prefer online facilities. Other than that, if I haven't already put a list of other recommended texts, I'll do that. But Tanya Sorden's text, Alternative Dispute Resolution, is very good. That goes into more detail about the ADR process and the major topics in this course. Another one is by Lawrence Boulay and Nadia Alexander. It's called Mediation Skills and Techniques. It's an excellent text, and you'd find that very useful for the first assessment piece. So, and we'll put this on the website, but Mediation Skills and Techniques. Another is Negotiation Strategy Skills by Alexander Howison and Fox. And that will benefit you in the first part of the course, but we will talk about skills throughout the course, and there's some others that I'll mention on the website. They're too expensive to go out and buy all of them, but you may be able to access them through library and other resources. Speaking of the library, those of you who've worked with me before know that I encourage you to go to the Supreme Court Library. It's open to members of the public. It's got free Wi-Fi, free printing facilities. It's got fabulous library resources and great staff, and really good private study facilities. If you go into the library, private study room 5 is my favourite. So if I find people, if I find my students are in study room 5, I'll say, hey, this is my room, get out. No, I'm joking. It's really good facility. So make the most of it. If you're in Brisbane or you're visiting Brisbane, please go and have a look. Now, Jamie asks a very good question. Does it matter which method we use, mediation or conciliation? Not at all. You can choose either of those, but do make it clear to me which way you've gone so that I can assess you based on that. And is anyone able to tell me the difference at this stage between mediation or conciliation? They're not the same thing. They are very similar. And I should warn you that ADR is so new that we're still grappling, I think, collectively with terminologies. What do we mean by mediation? What do we mean by conciliation? And in my discussion with Ellen earlier, you can see that my view of things is a little different to others in the field. But what's the difference between mediation and conciliation?
I understood conciliation as a more involved role than what mediation is. So they're very similar, but conciliation's more involved in the dispute as a practitioner.
Yep, I agree with that. Yep. Typically, the way I do conciliations is that I will provide a degree of reality checking and even advice work very guardedly, which I wouldn't do in mediations. So in a pure mediation session, you're really facilitating the parties to come to their own resolution. And in its purest form, you don't reality check, you don't provide options. You essentially let the parties come up with ideas. Lawyers find it really difficult in pure mediation work. Advisory mediation is much closer to conciliation, and it's where you do provide some ideas, some suggestions, some feedback, and in a limited sense, some advice as well. Giving parties an idea of what to think about. So mediation is really popular. If you do mediation work, I don't expect that you'll necessarily go with the pure mediation model, which is widely used in, say, dispute resolution centres around Queensland, but more of a mediation model that lawyers typically get involved in, where we do roll up the sleeves a bit. So the lawyer's idea of mediation is much closer to conciliation than might otherwise be the case. So think about that, do some reading about it, and identify a model that works for you, and then select whether you're going to be a mediator or a conciliator for that exercise.
John, just a quick question. In
Yes,
relation to the to the task itself for the assessment, if you wanting to do like a mediation, but a bit of a hybrid of it, because I've done a little bit of mediation myself, but it seems like my method's a bit of a hybrid of the two. Is that acceptable?
yeah, that's fine. Just announce it as being a hybrid, and maybe the idea is that you provide a little brief overview of the scenario, and maybe just a few words about your personal style or your preference, so that I can mark it accordingly. Because what I don't want to do is this. I don't want to tell you that this is the only way to do it, because that would be misleading. People do have their own styles, they do have their own ideas, and I want to provide you with maximum flexibility and come up with something that works for you, but still works within the established rules. So thanks, Anthony. Yep, if you do have a particular hybrid model, just let us know in the assessment piece, and feel free to share that with comments through UCrew, so that people get an idea of what to think about. But there are some established rules that you will be marked down if you breach some of those rules. So just be aware of that as well.
Okay, sure, thanks.
Any other questions, comments? Nothing? No, okay. Just with the weekly problems, I do encourage you to provide your answers, your responses. Do that on UCrew. The reason for that is that I want you to share your information and your ideas, and we can all make comment. I'll make some comments. People are normally really good in terms of responding to what others have said. So don't be shy about uploading your responses to the weekly problems. We actually don't do that through UCrew, we do that through Moodle. Everything else is really done through UCrew. And just, has everyone found their way to UCrew now? You've had a look? Please say yes. Okay, it's really important that we've done that. Oh, has everyone had a look at the way in which I like to see presentation of work? I've got a sample document. I think I've called it assessment guide or something. If you haven't looked at that.
No, I'm not familiar with that, John.
Okay. Has anyone else found it? There is always a risk that I haven't put it there. So yes, we have seen that. Okay. I think it's called assessment guide. It's probably about 4 pages, and it would be either near the top or in week 1 of, okay, I'm getting a lot of yeses, so it is there somewhere. And again, the assessment guide is nothing more than a guide. It's not something that you must follow slavishly. To be honest, many students come up with a better version of this than I've come up with. What I'd actually devised this when I taught Introduction to Law. In my first year of Introduction to Law, I was really disappointed with the manner of presentation. It just wasn't professional enough. Since I've been using, showing people this sample document and encouraging people to think about their presentation, overall the level of presentation has improved dramatically. So please consider that and feel free to use it or adapt it to your own style. And Jamie says, found it, it's under additional resources tab. Thank you, Jamie, for that. All right, I'm pretty privileged at the university in that I get to teach lots of different subjects. Last term I had environmental law for schools other than the law school. I did trusts and evidence, and I've done Introduction to Law quite a few times, statutory interpretation and environmental law. So environmental law and ADR have this similarity in that they're quite new disciplines. So I'm kind of at the cutting edge there of those 2 areas of law. The other one is probably e-law, e-commerce, and e-courts. So enjoy being involved in ADR because it's still a new area of practice and it's still developing. I do expect that you become familiar with key pieces of legislation. Those of you that have done civil procedure, you'll be aware of the Uniform Civil Procedure Rules and practice directions. When it comes to ADR, always bear in mind that the UCPR may be relevant, practice directions may be relevant as well. So, for example, in environmental law, for the Planning and Environment Court, there are specific practice directions that apply in relation to the implementation and use of ADR principles. So please be aware of that. It's really important that you follow practice directions where they are relevant. And also bear in mind that ADR is a process that can be standalone, or it can be used as part of the court procedure, or it can be done in both instances. So at the end of the year for the take-home exam, it's very likely that I won't spoon feed you with information about where to look. I'll probably give you a scenario and say, you think about how ADR might apply in these circumstances, either through the court processes, which are available, or independently of the court processes, or maybe a combination of both. So it's very open-ended, and I want you to be creative. This really is a course where you can be very creative in the way you go about doing things. And you can tell that from just reading the first chapter of our text. David Spencer identifies, I think, 14 different types of ADR process, and it's not likely that in the exam I'll say, all right, this is a question about partnering, and tell me how ADR partnering can be used to assist these parties that are involved in this factual scenario. I'll probably give you the factual scenario, and you then have to work out whether this might be relevant for a dispute resolution committee, or partnering, or conciliation, arbitration, or any one of the number of different ADR options that are available to you. So when you read your text, when you read about ADR, I want you to do it proactively in this sense, that I'm not going to ask you a question, name the 14 types of ADR that are commonly used in Queensland. You're not going to get that. So when you read about something, collaborative law, for example, I want you to think about how collaborative law might be used in practice, in a particular scenario. Now, sometimes the answers are almost self-evident when you read about these areas of practice, but I want you to think about a factual dispute and how you might select the ADR process and then apply it to deal with that factual dispute. It won't be the other way around. Does that make sense? Okay, good. So you can be very creative and you can have fun with it. I really do want you to have fun with this course. So it's going to be a little different to the other courses that you've probably done. Okay, it will be a short session tonight, but I do want to just touch on the applied skills in mediation. So this is really, in many ways, an applied course. So the first thing that you need to do when you're doing your study is understand the ADR options. You can't really give your client advice in relation to ADR unless you've first understood the ADR options and you've identified them and you've understood them. Second thing is, you need to be able to explain the ADR options to your client and provide advice about them. So here is an option that may be useful for you to consider. This is why we think it might be, or I think it might be useful for you in this particular situation. So once you've considered the alternative option or the options, and you've explained those options and a possible, you've provided some advice to the client about that option, you then need to understand the role of the participants in the ADR proceeding. So if, for example, you've decided that facilitation is the appropriate way to go, it's not just a matter of saying facilitation would be great for you, but you've got to be able to understand and then explain the role of the participants in, say, facilitation. What that means is that part of this course is for you to understand the basic procedures. So what you're doing in the first exercise is you're identifying the basic procedures involved in mediation and conciliation. They're really common. So you've got to understand what a mediator does, what a conciliator does, and you're going to play that part. So that's the best way of learning those procedures, because you'll actually be the actor undertaking those procedures. And you have to explain to people how they might participate, what's expected of them when they're involved in the ADR process. So your advice may have to involve preparing them for that ADR process so they understand what they're in for and how they are expected to participate. There are rules that apply to the participants as well as the mediator or the ADR practitioner. And then there might be some special skills and some specialty mediation or conciliation or other processes that we'll talk about during this course. So a good starting point for you this week is this. Make sure you understand UCRU and be involved in UCRU. Get involved in it. Second, make sure that you find your partners and let me know. Third, think about what you're going to have as your dispute scenario and start to talk, I'm saying partners in a loose sense, talk about these ideas with your colleagues, even make some comments on UCRU if you like. Then you need to understand the different options and start reading about those options actively. Have a look at the 14 different options, 14 different models, which are referred to in Bates, I'm morphing into environmental law there, in Spencer's book, and understand those as well. Learn the technology, make sure that you're aware of how you're going to do your course, your first assessment, and please don't leave it to the last minute. Start thinking about these things right now. Okay, have I scared you or encouraged you or a bit of both? Because obviously I'm here to scare you, that's the main. No. All good? All right.
All good.
Okay, so it'll just be a short session tonight. I will upload the session as I normally do. And if you have any questions, ideally ask through UCRU and we'll go from there.
Just one question, John, if
Yes,
I may.
Scott.
So just with the difference between conciliation and mediation. So conciliation is the person or the facilitator as such, whether it be conciliator or mediator. So the conciliator can provide input and advice on the matters and any applicable relevant law, whereas the mediator doesn't. He's more about process.
That's right. No, and that's a pretty extreme way of looking at it, and I'm being very guarded here because when you read about it, you've got to be really, really careful if you start to dip your toes into giving advice. So when I do conciliation work as a member at QCAT, I'm subject to very strict rules that apply. So it may be, for example, that if I did give some advice to a party as a conciliator, I would do so in a private session, and I would do so very, very carefully to ensure that I'm not influencing that party in the wrong way. But also I've got the teeth as a member in QCAT. I'm going to do a video with that. I can provide some directions. Maybe I'll I can provide directions by way of an order as well. So just be very careful, but I'll introduce it at this stage, but do think about it, but be careful if you're going to do conciliation. most people choose mediation because it is a safer option, but it's not necessarily as much fun, necessarily. So think about that. All right, now, Nasa, did you have a question? No? All right. Jackie suggests that you can use your mediation skills when I try and remove you from study room number 5 at the library. You'll need that. All right. Thank you for joining me tonight for our session. And we'll meet each week on a Thursday evening. And otherwise, we'll have a chat during the week on New Crew. I'll end the session now, and thanks for joining us. All the best. Bye.